Be ready. Start. By a notification dated 23rd October 1956, the Punjab government referred a dispute between the petitioner society and its workmen to Mr. Avtar Narayan Gujral as Industrial Tribunal sitting at Jalandhar. The question referred was a general one relating to the workmen as a whole regarding the question whether the management should be required to give any earned leave to the workmen, and if so, how much. While this dispute was pending before the tribunal, the society retrenched two of its workmen who were styled as checking inspectors on the ground that their posts were being abolished as superfluous and an unnecessary drain on the funds of the society. They were apparently given 1 month's notice and compensation as provided in Section 25FF of the Industrial Disputes Act. One of the workmen retrenched, named Amarnath, was a member of the workers' union, and his cause was espoused by the union, with the result that on 30 November 1956, before his 1 month's notice had actually expired, an application was filed by Amar Nath before the tribunal under Section 33A of the Industrial Disputes Act. This was duly dealt with by the tribunal under the provisions of Section 33A, and it was held that Amarnath had been wrongly retrenched and that the society had failed to make out any case for retrenchment and had not shown that the principle of last come, first go had been observed. It was accordingly ordered in the award dated 14th May 1967 that he should be reinstated without any break in the continuity of his service. It is this order which is challenged in the present appeal. The next question is whether the changes introduced in the amended section are merely procedural and a perusal of the relevant provisions of the two sections which I have already set out above is sufficient to negative this contention. There are, in fact, substantial and significant changes in the rights of employers and workmen in the matters covered by the section during the pendency of a dispute. Apart from this, the matter has already come before Meher Singh J and myself in Civil Writ number 257D of 1957, decided on 22nd April 1958, and we held that the changes in Section 33 were not merely procedural. A similar conclusion was reached in Karnal Cathal Cooperative Transport Society Limited versus State and others, LXI PLR 250. The learned judge apparently arrived at this conclusion independently since our judgment, which was not reported, does not seem to have been brought to his notice. Thank you.